Good morning, Mr. Mays.
Good morning.
Take a seat and you can proceed with your comments when you are ready to do so.
I know we're not supposed to have cell phones, but I want to make sure I don't talk too much. Thomas Mays, I'm currently an attorney with the Iowa Department of Education. I've been there 17 years, although it feels like yesterday. Before that, I spent 7 years at Iowa Legal Aid in Waterloo, practicing primarily in the 1st and 2nd districts, although occasionally in the 5th and 6th, because school district boundaries inconveniently do not follow judicial district boundaries. I appreciate the ability to be here today. I spent some time between those two practice spaces as a staff attorney with the Iowa Court of Appeals and assigned to the judge who has retired and whose vacancy this is, Judge Vidaswaran. I was also assigned to support Judge Eisenhower. During that 2 years, I had an experience with the work of the Court of Appeals, the type of cases they do, the type of disputes that come before them for a high volume and prompt and just disposition. And I'd like to highlight why I think I'm job ready. First, I think I have the ideal temperament to be a judge in that I believe in a light footprint. I think that the purpose of the Court of Appeals is to decide a high volume of cases justly, and the focus should be on what a case is and what a just outcome is, in that deciding a case and deciding a case justly, the panel should be they're actually the least important people in the transaction. The most important people in the transaction are the litigants. So if the panel imposes its will, imposes its personality onto the parties, onto the litigants, that is something that the litigants will have to deal with for the rest of their life, long after the case is over. So if the panel has a heavy footprint in a child custody case, does not act with grace, dignity, humility, decides more of the case than necessary, puts uses language that might not be dignified to the parties, that ripple effect and cascading effect will follow that child and that family for the rest of the child's and the rest of the family's life. So light footprint, deciding only so much of the case as is necessary, resolving cases promptly, resolving cases justly, and empowering individuals to take what the court has decided and continue to live their lives. The ideal outcome would be that the litigants forget who was on the panel and the court never sees the litigants again. And I think even if that is impossible, that is what district court judge, Court of Appeals panel, Supreme Court sitting en banc should strive for. By empowering individuals to solve their own problems and live their own lives, I'd like to briefly talk about a personal interest of mine and then open up for questions, comments, or insults. The personal interest of mine is appellate mediation, and I've been an end user of it in the United States Court of Appeals for Veterans Claims. It has helped resolve cases promptly. It's mandatory in that court. Every case is screened for a settlement conference before a mediation-trained staff attorney. And in 3 of the 4 cases appeals that I've taken to this court, the secretary confessed error and agreed to a remand. My clients got their benefits. Their surviving spouse got their surviving parent got their benefits sooner rather than later. And I think that is something that, because we are a state of Iowa nice, and we are a state that likes to resolve problems, or says they like to resolve problems. I have had a continuing interest in appellate mediation, and if I'm the successful candidate, I would be, that's a change that I would be willing to champion, at least on a pilot basis. Other than that, my bio is in the application. Thank you all for reading it. As Dr. Phil would say, I've got more degrees than a thermometer. Undergraduate degree from Baylor, law degree, Sikkim, law degree from Iowa, and a bonus master's degree in education administration from Lehigh University. So thank you for your service on this commission this morning, and I'm ready for questions. Fire away.
All right, thank you. Commissioner Graber?
I feel many times in the decision process to do something big like this, we reach points where we have some doubts maybe that we want to do this. Specifically for you wanting to be on the Court of Appeals, did you ever have some doubts on whether you really wanted to do this position?
I think everybody, if it's a big decision, should have some doubts. I've been through this process 4 times before. I wouldn't have put my name in had I not thought that those doubts were reasonable, or my personal concerns, or, I was told growing up, don't mess with happy. I love my job, but I feel every day it's fun. It's like vacation. But had I not felt that I could do this work, I wouldn't have even put in the application. So I think it's a healthy amount of doubt. I haven't, aside from my veterans cases and my own traffic tickets, I haven't been to court in 10 plus years. So there's that. But when I started practicing before the VA court, it was like getting back on a bicycle. So I think that's the one doubt I have, being in-house for 17 years, but I feel that my prior experience would surmount that.
Thank you.
Commissioner Chase?
Thank you for your application. I am curious to hear more about the trial work that you have had, whether it was jury trials or bench trials, and what kind of clients you were representing.
No jury trials. At legal aid, civil legal services, civil legal assistance to people with low incomes in matters where the private bar would not take the case, so no personal injury. Around a third of my litigation was family law, establishment or disestablishment of paternity, child support, child custody, from 15-minute review hearings to 4 to week-long trials. About a third of my litigation was housing, from a 15-minute eviction defense to a half-day housing standards. My client had problems with the septic system and the basement, and there was issues getting, it was too big to do repair and deduct for. And about a third of my caseload involved public benefits, Medicaid, food stamps, housing assistance. And again, those were primarily before administrative agencies, from 15 minutes to a day, with judicial review on occasion.
Thank you.
Commissioner Pearson?
Actually, my comment here is just more of a comment. When we talked, you talked about the mediation option concept, and thank you for addressing that today.
Commissioner Marquardt?
When we met individually, you mentioned that in the last year you've used, I believe, every class that you took in law school in your role at the Department of Ed. Can you tell the commission some more about that?
Well, education law is broad, that a lot of tentacles outwards. Education is at the state level, is a $500 million investment each year. And with the size of that stake of the state's economy, there is, it strays into every practice area. So within the past year, I've read title opinions, because the statute requires the director of education to approve any sale of property by a community college. Who knew? I hadn't thought about a title opinion since bar prep, but yeah, tax law. Who is eligible for the education savings accounts based on taxable income and what line of which return is used? Criminal law, providing support to school districts regarding abuse of students by teachers, coaches, and volunteers. Intellectual property. Use of the department's logo and marks in marketing by private schools. I received a cease and desist letter a few years ago from the Corporation for Public Broadcasting because the Iowa Department of Education was branding a support structure as Positive Behavior Supports, PBS. And PBS is like, they're almost like Disney. They are very jealous of their marks. And so I got a nasty gram from Washington, D.C. from the Corporation for Public Broadcasting. Please stop calling your stuff PBS. The immigration law class I took just for fun. Visa status, when can schools, if ever and never, ask for immigration status? So every class in law school within the past year, in addition to the class on education law I took.
Commissioner Henderson,
No questions, thank you.
Commissioner Parrish.
Thank you for your application. Would you share with the commission what you call the very valuable lessons or experiences you had as a legal aid lawyer that would make you a good addition to the Court of Appeals?
The value of being heard. And I think I told this story to at least one commissioner. I was representing an individual in a special education mediation. We went mediation before, and there's that word again, mediation before an administrative hearing, and the case didn't settle at that moment. There was no agreement at that moment, but my client afterwards thanked me profusely because for the first time ever, the school folks had called her by her preferred term of address, Mrs. last name, rather than addressing her as her first name. And it took a lawyer being in the room, but she and her desires were heard. The school district was trying to be friendly, but to my person's perspective, they were being overly familiar. And the fact that my client felt heard. So anytime individuals feel heard, and anytime that the least dangerous branch can provide mechanisms where folks are heard more, heard better, I think that's the most important lesson I took from those 7 years.
Thank you.
Commissioner Hoig.
Thank you for applying. What do you think would be your biggest challenge if you were to be on the Court of Appeals?
Going from the Grimes State Office building to this, the biggest challenge would be giving up sort of a content area, a practice space that I love so much. But that's it. I really have a thing for education law, but it's not the sole thing, and it might not be the highest and best use of my time. So I think that would be the struggle. Understanding that very few school law cases make it to appeal in Iowa because school folks and parents' attorneys are very skilled at settling cases.
Commissioner Hoytink.
Thank you for your application. Hearing you speak, as a general counsel of a company myself, you're a general counsel of an agency. Talk a little bit about how that experience would translate to the bench. So on a day-to-day basis, you probably have your own jurors who are your constituents. Your decision-making could possibly be appealed to a judge, to an appellate court, to a different lawyer, and you have to make decisions. So you just talk a little bit about how you feel, you've sat at the Court of Appeals, how you feel like that general counsel practice translates in your ability to review cases and your ability to do appellate work?
Two things: the value of preventative law and the butterfly effect, because folks who are in-house see the cascading effect of advice or decisions. And so just a reinforcement that the butterfly effect is real, and for that reason to be humble and have a light footprint.
Thank you.
Commissioner Schnurr?
You mentioned the light footprint again, and you mentioned it earlier. Could you tell us how that would influence or inform your approach to writing and making decisions and writing decisions if you were to be on the Court of Appeals?
I've had this, when I was a staff attorney, had this discussion with several judges, and one controlling case is good enough. One dispositive rationale is sufficient. And reasoning in the alternative sometimes is necessary, but sometimes I think the best opinion is like electricity. It takes the path of least resistance. It finds its level. If there is a dispositive issue, we've considered all other issues presented, but this is it. And not necessarily reasoning through issues that don't add value.
Thank you.
Commissioner Roberts?
Thomas, you have the sort of like distinction in our group of 16 applicants. I think you're the only one of the applicants who received a letter of recommendation from Judge Vithasworn herself, which I thought was pretty notable that you received a letter from a judge whose vacancy we're working to fill today. So do you mind kind of speaking to your relationship with the judge and what this commission should be thinking about as we're making nomination for her replacement?
That letter might be the highest honor of my professional career so far. I was her staff attorney for 2 years. I shared assignment with Judge Eisenhower, but she and I also presented together and converted a couple of those presentations into law review articles, one on error preservation. Filing a notice of appeal does not preserve error, but my professional identity is closely tied to hers for those two reasons. And the fact that she thought highly enough to write a recommendation letter is something I will never forget.
Thank you.
Commissioner Samorov?
I have no questions, thank you.
Commissioner Picklop?
I have no questions, thank you.
Commissioner Stanger?
Mr. Mays, you and I share a passion for serving veterans, and it's a unique role that a lot of other practitioners or members of the court aren't aware of. The designation you have to represent veterans in front of the Court of Appeals is a unique designation. I'd like you to talk about what you've learned and gained from that experience.
Learned personally, if I can at least minimally competently understand VA law, I can understand any area of the law. And then professionally, the importance of digging into details. One of the cases, the VA conceded error because I pointed out in a form that my client filled out, the series and date in the footnote, that the form was in use at the time she said she filed it. The VA lost her file. And so with her copy having that date on it, which was only available at the time she said she filed that form, just the importance of even reading footnotes, the fact that I read the footnote and pointed out the year was dispositive.
Thank you.
Commissioner Hanson?
No questions.
Commissioner Spies?
Thank you. One thing that struck me as you talked about footprints, and I think you kind of infer or imply that you can dovetail language in a way that's not only understandable but demonstrates the respect that the court gives to the litigants. Could you comment about the tone of language used by the appellate courts in Iowa and how you agree or disagree with that tone?
The court's currency, the widgets it makes is deciding cases through opinions. And I think the do no harm should be the approach. Does the opinion add value, add dignity, add to the respect and the majesty that this court and this building deserves, or does it not? I think another reminder is it is the court's opinion, the court's decision, authored by an individual. So the court speaks, not Judge Mays, Judge Ivory Towers, whoever it may be. So those two things are constant reminders to myself when I read and critique opinions and think, would I have wanted to have been remembered for saying and writing that? And would I want to be on the receiving end of that which is said or written?
Thank you.
And I see our time is up. So we thank you for your application, and we wish you well.
Thank you.